At this stage, it would be appropriate to notice Section 109 of the Transfer of Property Act, 1882, for short, the TP Act, which states as under 109. Rights of lessor's transferee. If the lessor transfers the property leased, or any part thereof, or any part of his interest therein, the transferee, in the absence of a contract to the contrary, shall possess all the rights, and, if the lessee so elects, be subject to all the liabilities of the lessor as to the property or part transferred so long as he is the owner of it, but the lessor shall not, by reason only of such transfer, cease to be subject to any of the liabilities imposed upon him by the lease, unless the lessee elects to treat the transferee as the person liable to him. Provided that the transferee is not entitled to arrears of rent due before the transfer, and that, if the lessee, not having reason to believe that such transfer has been made, pays rent to the lessor, the lessee shall not be liable to pay such rent over again to the transferee. The lessor, the transferee and the lessee may determine what proportion of the premium or rent reserved by the lease is payable in respect of the part so transferred, and, in case they disagree, such determination may be made by any court having jurisdiction to entertain a suit for the possession of the property leased. 19. A careful perusal of the aforesaid provision would show that when the right, title and interest in a movable property stands transferred by operation of law, Section 109 of the TP Act would apply and the successor in interest would be entitled to the right of his predecessor. 20. The Supreme Court in Taraknat, Supra, has held that since the purchaser gets valid title to the property and the respondent was continuing as tenant, he is bound by title since the suit has been laid for eviction of the tenant and held as under 4. The sale deed is a registered conveyance for valid consideration. Under those circumstances, by operation of Section 17 of the Registration Act, 1908, the appellant gets valid title to the property. Ellipsis quote. 21. The Division Bench of the Madhya Pradesh High Court in BP Pathak, Supra, held that Section 109 of the TP Act creates a statutory attornment and applies in three cases: I, where the lessor transfers the whole property leased; E, where the lessor transfers the property leased or any part thereof; and E, where the lessor transfers the property leased or any part of his interest thereof and held as under 19. All these problems are solved by Section 109. In our opinion, that section creates what may be called statutory attornment, which substitutes, and has the same effect, as contractual attornment, so that because of a transfer of the leased property, or a part thereof, the transferee ipso facto acquires all the rights of the lessor, and a new relationship is created between the transferee and the lessee. Letter of attornment is not necessary to complete title to the assignee of the reversion under Section 109. Title of the assignee is complete on the execution of the deed of assignment and is not postponed till the notice of assignment. See Pulin Bihari v. Miss Leela Day, Air 1957, Cal 627. This relationship is statutory. It is not dependent on the consent of the lessee, liabilities of the lessor apart. This is by force of the statute. Ellipsis quote. 22. In BP Pathak, Supra, the Division Bench of the MP High Court further laid down the following principles of law with regard to Section 109 of the TP Act by observing as under 28. The above discussion leads to the following conclusions. 1. It is settled law that in the absence of a specific provision in the statute, the tenancy cannot be split up by one of the parties without the consent of the other. The court or the rent-controlling authority also cannot split up the tenancy. The lessee can be ejected from the whole of the demised property or not at all. Ms. S. Sanyal v. Giachon Air 1968 SC 438 and Shantaram v. Shyamsundar Air 1972 Madhya 17. 2. If there is a specific provision which gives the court or the rent-controlling authority power to split up the tenancy, the statute will override, for instance, Clause 13(8) of the CP and Berar Letting of Houses and Rent Control Order, 1949, Nathulal v. Ritansi 1957 MPLJ 805 equals, Air 1958 Madhya 218, Facebook. 3. If the lessor transfers any part of the property leased, the transferee, by virtue of Section 109 of the Transfer of Property Act, acquires all the rights of the lessor in respect of that part of the property. This means that the transferee possesses all the rights in that part of the property as if it had alone originally been comprised in the lease. If not already determined, the transferee is entitled to determine the lease and sue for ejectment. 4. If the lessor transfers any part of his interest in the property leased, the transferee becomes a co-lessor and as such, the transferee alone cannot determine the tenancy or sue for ejectment without the other co-lessor joining him, or unless and until the transferee gets a partition effected. 5. For the purposes of Section 109, a partition is a transfer of the part of the property allotted to each co-owner. It automatically splits up the tenancy. 6. Section 109 creates statutory attornment and has the same effect as if the lessee by contract attorns to the lessor's transferee in respect of the property transferred, whole or part, as the case may be. 7. Although the wording of Section 140 of the English Law of Property Act, 1925, is somewhat different from that of Section 109 of our Transfer of Property Act, the effect of the two provisions is the same. 8. The right of ejectment is inherent in ownership. 9. A transferee of a part of the property leased can determine the lease in respect of the part transferred, in any of the circumstances enumerated in Section 111 of the Act, and sue for ejectment. There is nothing to restrict this right of ejectment to cases where the lease had been determined before the transfer, or to cases where the lease is determined by efflux of time.